Court all rise. Hear ye. All persons having anything to do before the Honorable, the Justice Susan Gosh of the Superior Court, now sitting at Fall River within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Be seated, please.
2013-983, Commonwealth versus Hernandez. Counsel, please identify yourselves for the record.
Good afternoon, Your Honor. William McCauley for the Commonwealth. With me, Roger Michael.
Good afternoon, Your Honor. Michael Fee. With me, James Sultan, Charles Rankin for the defendant, Aaron Hernandez. Your Honor, may Mr. Hernandez's handcuffs be removed for the purpose of the hearing? Thank you.
They may. And let me please remind all of you that in accordance with the SJC rule governing electronic access, there is to be no electronic recording or transmission of any bench or sidebar conferences, any conference between counsel, and any conferences between counsel and the client. And if you're not operating one of the two cameras here, then you cannot use your cell phone, camera, or any other electronic device to take any photographs. Finally, anyone who is not an authorized representative of a news organization that is registered with the Public Information Officer of the Supreme Judicial Court, or an individual who is so registered, must have his or her cell phone turned off or any other electronic device turned off, not just silenced, and put away. That includes lawyers and members of the public. You are not authorized to use a cell phone, camera, or any electronic device to photograph, record, or transmit any aspect of these proceedings or for any other purpose while you're inside this courtroom. I'll take up first the discovery motions that have been filed, and then the defendant's motion for bill of particulars. Turning to the defendant's motion for discovery, what I'd like to do is hear argument separately on each of the, I think it's five matters, so I'll first hear from defense and then let the Commonwealth respond as opposed to doing them all as a group.
Thank you, Your Honor. And let me say at the outset, we've endeavored to limit the number of discovery items which we had to bring to the court's attention. The parties corresponded with each other. We've met in an effort to minimize what has to be litigated here in court, and the motions we filed are what's left after our attempt to work with the prosecution. Number one, Your Honor, on our motion for discovery is a request for copies of notes made by law enforcement officers during the course of this investigation outside of Massachusetts. Based on the discovery we've received, there has been considerable investigation done outside of the Commonwealth, and under Rule 14, to the extent that those individuals, whether they're Massachusetts law enforcement agents or agents of other law enforcement agencies outside of Massachusetts, presumably they've been reporting to the prosecutor's office in this case, and under the terms of the rule, we believe that notes resulting from such investigation should be treated like the notes of Massachusetts law enforcement agents and should therefore be turned over to the defense as part of discovery. And the prosecution apparently does not agree.
To the extent you're seeking all notes made by law enforcement, if those notes are incorporated into a police report, is it that you're seeking, is there anything under the rules that would give you the ability to get the notes?
Well, Your Honor, I think I guess the statement, I mean, the rules define what a statement is. To me, if a law enforcement agent makes handwritten notes and then produces a report, the handwritten notes remain a statement. It's a It's something that if that person is either a potential witness, or to the extent that those notes incorporate the verbatim or substantially verbatim account, I guess I need to look at Rule 14 to get that precise language, but to the extent that those notes, either if that law enforcement agent may be a witness at trial, those notes would be a statement of the witness, and to the extent that those notes otherwise incorporate the substantially verbatim account of some other witness, then they would be statements and discoverable, and I don't see why it makes any difference.
The term statement under Rule 14 say, other than drafts or notes incorporated in a draft or final report.
Well, Your Honor,
so I was just questioning your all notes.
Well, I think without, I suppose if the report is a verbatim recapitulation, that is, if they simply rewrite the notes word for word into a report, I would agree that we don't need to have the handwritten notes. In my experience, I often see handwritten notes from law enforcement agents which are not replicated word for word in a report. Some things may be added to the report, some things may be omitted from the report, and to the extent, for example, that there's something in the report that's not in the notes, that will be subject for cross-examination at trial. Well, it's in your report, you didn't put it in your notes. So to me, that is material which, whether it relates to inconsistent statements, whether that's material that we need to prepare to cross-examine the Commonwealth's witnesses at trial. So, and without, so I suppose it would be all notes other than those which are replicated verbatim in a report. We're not looking to kill more trees unnecessarily, but unless the report is nothing more than a verbatim recapitulation of those notes, I think we should be entitled to those notes.
Thank you.
Yes, good afternoon, Your Honor. Your Honor, we have agreed to provide notes for the agencies in the state, which essentially, as Your Honor points out, goes beyond the rule. And to the extent that my concern about the request and elsewhere, the broadness of it, and as well, that we have a number of organizations or agencies that are working with us from out of state. They've been cooperative and continue to be cooperate with the investigation, the prosecution. But if we got into a situation where they said we're not turning those over, obviously, then I'm not in a position to compel them to do anything. So I wasn't going to agree.
It's a two-step process. One is, if it was the federal government, if it was the FBI, right, there are a whole lot of cases that talk about if there's any cooperation, the state has an obligation to request from the FBI, even though it's a different sovereign. Why would any, so just doing the request side of it,
I agree.
is there any obligation?
We're making every effort to get everything we can from any agency that's been involved.
So you don't object to requesting?
Absolutely not, Your Honor.
And at this point, you haven't heard back from all the agencies?
Well, they're in various stages of trying to comply with our requests or undertaking to comply with it.
Thank you. Next.
Next, Your Honor, number two. Based on the discovery we received, there seems to be quite a bit of forensic evidence in this case. And in order for us to both evaluate the significance of that forensic evidence and potentially to test its reliability, we need the records we've asked for, which include, which are really some of the subjects which are, as I recall, specifically referenced in Daubert and Lanigan as some of the criteria that a court will look to in determining whether or not forensic test results are admissible, including the error rates, protocols, whether or not the persons doing the testing have been trained properly, whether the protocols are valid, whether the protocols have been adhered to. Without that kind of information, we simply are not in a position to evaluate and potentially challenge that forensic evidence. So we've asked for what we need to accomplish that necessary task. And I think based on recent experiences in the Commonwealth, it's quite clear that forensic evidence It can't be taken at face value. It needs to be carefully assessed, and we need the tools to do that, Your Honor.
Wasn't entirely clear to me from the request whether you're limiting it to equipment or persons who actually tested evidence in this case.
Well, Your Honor, I think
or the quality control issues with respect to the materials and equipment actually used in this case.
I think that was
proficiency.
With respect to B, that is materials and equipment utilized in said testing, yes, Your Honor, I think that that's fair. We don't need to know about some equipment in a different part of the laboratory that had nothing to do with this case.
Right, and the same with respect to the proficiency testing, you're
Yes, Your
looking
Honor.
for proficiency testing of the people who actually did the test in this case.
I would say people who either did the testing or who served as technical reviewers, people who were involved in some direct way in evaluating the evidence in this case. Yes, Your Honor.
Thank you.
Your Honor, our objection, we had agreed to the most recent inspection report in the laboratory by accrediting organizations. Felt the rest of it was overly broad. We are producing the individual examiners and their CVs as in terms of the information that would go to their ability to testify and be cross.
If there are error rates, for example, wouldn't that be exculpatory?
Well, to the extent, Your Honor, that I guess if there's actual evidence of it being not in accordance at that time they did the testing versus at any time in the past is there an error rate? I don't know that, again, the equipment itself, when it was used at the time of its use, whether it was meeting all the standards, and again, I guess if we knew there was some error in the testing, absolutely that would be exculpatory, but he's looking for 5 years of history, the past 5 years of testing. I don't see how that, one could say that's necessarily exculpatory.
Thank you.
I turn to number 3, Your Honor. Number 3, Your Honor, something I've become increasingly sensitive to, that is any public internet posts made by a potential Commonwealth witness. Frankly, Your Honor, I think this fits...
Not by any Commonwealth witness or by an agent of the Commonwealth?
Oh, an agent of the Commonwealth, Your Honor. Although...
There's Rule 14, they only have to provide things in their control of an agent, right?
Well, Your Honor, Rule 14A1, A7, little 7, refers to statements of persons the party intends to call as witnesses. Doesn't limit it to their agents. So it seems to me if they were...
Before you get to A1, isn't all the discovery relate to those items before you get to that subpart that are in the possession, custody, or control of the prosecutor or persons under the prosecutor's direction and control or persons who have investigated?
Absolutely, Your Honor. Yes.
So a witness who's not law enforcement or someone in the lab or someone who's otherwise in the control.
Unless they were, well...
They may be a witness, but they may not have control over to be able to get from someone. I mean, they're only required to produce, even with statements. That's all under A, which it begins by saying, provided they're in the prosecutor's direction and control.
Well, I think Your Honor is correct, I think, that in terms of mandatory automatic discovery, it would be limited to what's under capital A, which would be agents.
Your heading talks about witness agents. The heading of your...
That's true, Your Honor. So I stand corrected. Let's talk about their agents. So I guess we are talking mandatory discovery. We're talking simply about their agents. And to me, if there's a statement by an agent who may be a witness, whether it's on a blog or on some social media site or wherever it may be that relates to this case, we should have access to it under the rule.
Thank you.
Your Honor, I agree with the proposition if there's a statement put out by one of our agents, that, but at the same time, it's so broadly written as to then require some investigation into this matter. Any statements that we have, we've provided. And so there's an ongoing obligation to do that statement.
I mean, isn't your problem with the definition of statement in the rule? I mean, some states have adopted a definition of statement which requires a degree of formality, whereas our definition of statement doesn't. It's just any writing signed by a person with percipient knowledge.
Right, and I agree. If there's an agent of ours who's putting postings, about the case, that becomes a statement. And obviously, if we learn of that,
well, but if you say if you learn, isn't there an obligation under the rule to investigate with respect to your own agents, with respect to automatic discovery?
Well, to the extent of any statement, we've asked people to provide any reports, which are their statements. I presume if the court would feel better about that, I would specifically ask them, are there any other statements that you've made regarding the case, and then to provide those to us, and we'll be glad to turn those over.
Number 4, Your Honor, is very specific. There is a typo. It should say Belglade, Glade, Florida. This refers to a statement, an interview of a witness, which is referred to a discovery. It seems important in the case, and we've been inundated with discovery lately. It's possible that I've missed this one, but I don't think so. I think this has not been turned over, and I don't know why it hasn't, but it's clearly relevant. Maybe it will be exculpatory, and that's why it's included in the motion.
Your Honor, we are working, this is one of those situations we're working with an agency to gain access to any of those reports. So
this is one of these out-of-state agencies that you're working with?
A agency that we don't have control over.
Right, but it's not a Massachusetts.
Well, it's a.
You were saying it was made in Florida. Was it made to a Massachusetts agent, law enforcement agent?
Well, it's actually made to an agency, a national agency, I guess I would answer it that way, Your Honor. So to the extent that we've made a request, and as they respond to that, or if they don't respond to that, I will apprise the attorneys for Mr. Hernandez.
Thank you. And
last but not least, Your Honor, and again, I may have missed this in the turnover of discovery to date, which is quite voluminous, but I don't think that I have. An important part of this case has to do with events that occurred at the Rumors nightclub on the night of Friday, June 14th, 2013. And if there are any credit card receipts for Mr. Hernandez or the 2 people who were allegedly with him at that nightclub that night, Mr. Olivares or Mr. Lloyd, they're clearly material and would like to have them. They may be exculpatory.
if they don't have them, if they haven't sought them or don't have them, then you would have that same ability under Rule 17 to seek them.
We would.
So you're just saying if they have them, produce them.
Yes, frankly, Your Honor, based on...
Was there any objection to producing them if they had them?
Your Honor, I think this was one that we did not include in our letter, so I don't think we've addressed that with Mr. McCarthy.
Unlike the agents, this isn't one that you're saying if they don't have them, they have to go look for.
Of course not, Your Honor. Your Honor, based on what we've seen so far, it is inconceivable to me that if these exist, they don't have them.
Your Honor, we've turned over a bunch of financial records. So again, this was not included in the original request, so I'm not in a position to answer whether they are or to what extent they are, but everything we have financial related has been turned over.
Including any credit card receipts for
Correct,
goods or
Your Honor.
services. Do you know whether you have any? Do you know whether there were any that were produced?
I believe some part of this there were, but again, I don't want to answer at this time without knowing for sure.
Thank you. With respect to the defendant's motion for discovery, the copies of notes made by law enforcement officers during the course of the investigation outside Massachusetts, and the copy of any documents, recordings, memorializing a statement made to law enforcement agents by Oscar Hernandez in Belglade, Florida on June 27, 2013, and any subsequent statements. The Commonwealth does not take issue with the fact that it has an obligation to request these records to the extent that you are seeking that the Commonwealth requests the records. To that extent, the court will order the Commonwealth to attempt to obtain from the relevant out-of-state law enforcement officials or agency those records. There is no reason to distinguish here a out-of-state sovereign, which may be another state or local, out-of-state local agency, from the FBI, where the court has imposed a duty to attempt to get the information, even though the state has no control over the FBI. It's a separate question, and it is simply premature to reach that question, whether if any of these documents are not produced, the state, their failure to produce may be imputed to the Commonwealth. To trigger the obligation to request, there just has to be shown some degree of cooperation. However, to hold the Commonwealth responsible for the failure to produce, there must be a very high degree of cooperation between the two sovereigns. There have been cases where the Commonwealth has been held responsible for the failure of the FBI to produce a document when requested, even though the Commonwealth did not have control over the FBI, because the court found there was such interrelationship of the investigation. That is a fact-dependent inquiry, and until the Commonwealth knows which agencies or out-of-state offices are not producing, I would require the Commonwealth not only to make the request, but to advise the defendant of which law enforcement agencies out of state, if any, are refusing to comply with the Commonwealth's request. And then, if appropriate, there can be some further hearing at some future time as to whether there is the kind of cooperation as in the Lycus case, where the failure to produce is imputed even though the Commonwealth has no ability to get those records by control.
I guess that's my request, Your Honor, that the court essentially order the Commonwealth at some point to report to us either here the stuff is, or the following agencies refuse, and then we can
require the Commonwealth to report to Defense Counsel. I don't think anything needs to be filed in court unless you're not satisfied with that, or you, with respect to the state police crime lab records, A has been agreed on. D, which is the relevant protocols governing the testing, are material and relevant to the extent the Commonwealth intends to introduce the results of any such tests, and the Commonwealth is ordered to produce those protocols. Although Rule 14A1 does not mandate their production as automatic discovery, Rule 14A2 does allow the defendant to seek discovery of material and relevant evidence that the Commonwealth is not required to produce as automatic discovery. The court finds that without access to the protocols, the defendant is unable to assess the validity of the protocols or to effectively explore before trial or at trial whether the protocols were complied with. With respect to E of the defense request, the known error rate, if there is a known error rate for the type of testing done, whether it be DNA or fingerprint or whatever testing is done, if there is a known error rate for the specific type of testing utilized on evidence in this case, that fact would be of an exculpatory nature. In the Williams case, the SJC stated that evidence tending to call into question the validity and quality of scientific testing in the defendant's specific case would qualify as favorable to the defense and thus exculpatory. Thus, the Commonwealth is ordered to produce, if the lab has such a document, or if the lab is aware of the error rate and supporting documentation to the to the extent it exists, with respect to the types of tests that produce the results that the Commonwealth intends to introduce at trial. With respect to B, which seeks records documenting quality control of materials and equipment actually utilized in testing, only to the extent there are documents that reflect any problems with quality control for the materials would that fact be of an exculpatory nature. If there are, it would be of an exculpatory nature because it would call into question the validity and quality of scientific testing in this case. Accordingly, the Commonwealth is ordered to produce records for a 2-year period prior to the testing, if to the extent any such records exist that reflect any problem with quality control with respect to the materials or equipment actually used in tests, the results of which the Commonwealth intends to introduce at trial. Finally, with respect to the persons performing or confirming the tests, the defendant has requested all documents evidencing internal and external proficiency testing during the past 5 years and the results of such testing only if the persons performing or confirming the test did not get the highest proficiency rating when they were tested internally or externally, would that be a fact of exculpatory nature. If they did not get the highest rating, that would be a fact of an exculpatory nature because it would tend to cast doubt on the credibility of a Commonwealth's witness or tend to call into question the validity and quality of scientific testing in this specific case. For this reason, the Commonwealth is ordered to produce such records to the extent they exist with respect to persons who performed or confirmed the tests, the results of which the Commonwealth intends to introduce at trial for a 3-year period prior to the performance of the tests. The prosecutor has a duty to inquire of the laboratory to see, or each laboratory, to see whether such information exists. With respect to the public posts, the defense has clarified, to the extent it was unclear, that its motion seeks only postings by prospective Commonwealth witnesses who are also agents of the Commonwealth. The rule requires production of statements of persons the Commonwealth intends to call as a witness, which are in the prosecution's possession, custody, or control. And our state defines statement as a writing made by a person having precipient knowledge of relevant facts and which contains such facts, other than drafts or notes that have been incorporated into a subsequent draft or final report. To the extent that an internet post was made by a person having precipient knowledge of relevant facts who is an agent of the Commonwealth, and to the further extent that the post contains such facts and was made by a person the Commonwealth intends to call as a witness, it is a statement that, if it exists, must be produced in discovery, and the Commonwealth is ordered to produce such postings. Similarly, to the extent the posting, even if not made by a person with precipient knowledge or not containing such facts, is inconsistent with any testimony the Commonwealth expects to elicit at trial, or which contains any statements that might show hostility or bias, then those postings would be exculpatory and must be produced. While there did not appear to be any Massachusetts case that the Commonwealth located, nor that either party cited, other jurisdictions have found that emails may constitute statements under a similar rule. The prosecutor, a prosecutor's belief that no inquiry is necessary based on an assumption that the prosecutor already has all the items and information subject to discovery is not sufficient to comport with Rule 14A3, which doesn't limit the duty of inquiry to those instances where a prosecutor becomes aware that additional discovery materials may exist. Accordingly, those are ordered. With respect to the credit card receipts, it does not appear as if any order is necessary. The Commonwealth has represented that it has turned over any credit card receipts for goods or services purchased by Mr. Hernandez, Mr. Olivares, or Mr. Lloyd at Rumors Nightclub came into its possession. Credit card receipts, as you would expect, then the defendant certainly is free to move under Rule 17. The Commonwealth is not required to do so. I'm not sure we need to go through the 55 paragraphs of where you have requested the Commonwealth to state whether it has produced all agreed upon discovery to date, and if not, when it intends to complete the production. I noticed in the Commonwealth's response, there were times where it said they had been produced and other times where it said they're about to be produced. Maybe I could just get a sense from Ms. McCauley as to how much of the 55 requests do you think that the Commonwealth agreed to produce have already, what percentage you think has been produced, and when do you think that it will all be produced by, leaving aside the out-of-state records over which the Commonwealth has less control?
I think, Your Honor, at the time we met, there was an additional bunch of information that was provided, and there had previously been information provided that actually addressed some of the things. That's why we were in a position to agree to 50 of the 55. There are some things still outstanding. I think the defense might know what a few of those things are relating to some testing that we're still waiting on the results of. But I would say most of it has been produced, and again, some of this will continue to come to us, and as we get it, we're turning it around fairly quickly. I actually delivered today some additional materials. I think where the majority, substantially most of it has been provided.
Is there any action you're really asking the court to take on this motion?
I think I really filed a motion, I think, in abundance of caution, because I know the court is wants to see the case progress, and I just don't want to be put in a position where we are.
Counsel will do as well.
Yes, we do, Your Honor. Certainly for our client who's incarcerated, we do. I don't want to be put in a position of having to essentially move toward trial until we know we have all the discovery. So that's really why I filed a motion.
There may be pieces. I mean, in every case, the Commonwealth files certificates of compliance and more stuff comes. There may be pieces in terms of out-of-state records maybe coming in, dribbles and drabs, and testing. Laboratory reports may not be all here. Is there, I mean, are you in a position, our counsel both in a position to complete a pretrial conference report today?
I think we could do that, Your Honor. I don't see why not from the defense standpoint. The fact that discovery is ongoing, I don't see why that would interfere with our ability to do that.
And I'll deal with some dates after we deal with the other motions. Endorse.
I think that's fine, Your Honor, at this time. Yes.
Thank you. there is, for production of bristles.
We'll address that. Thank you.
Yes, Your Honor, we submitted a motion which has been provided to counsel for the defendant. You've had a chance to review it as well. What we're seeking is a subpoena to obtain certified copies of all the documents listed in the motion that we filed. These include the visitor records, the contact list, and then whatever copies they have, either in the form of audio files or transcriptions, however produced, of the telephone conversations described in the motion.
10 of the filing states both of these co-defendants, referring to Shayanna Jenkins and Tanya Cummings, quote, have been charged as accessories in the underlying offense of murder on the theory that they provided assistance to the defendant after the commission of that offense. Unless there have been some superseding indictments, the court's docket, that are not docketed, the court's docket shows that Ms. Jenkins was charged with perjury and was never charged with accessory, and that Ms. Singleton was charged with contempt and conspiracy to commit accessory, but that she was never charged as accessory. So I just not sure of that paragraph.
Charged in connection with, not as co-defendants.
There's nothing in the affidavit that indicates whether the person providing the information from the sheriff's department was an employee who actually monitored the calls, or whether that employee prepared a report that was read by someone else, or whether that person told B, who told C, who told D, who told E, who told F, who told G, who called the DA's office, without knowing how many layers of people, from the person who listened to the person who reported. How can the court determine that the hearsay is reliable?
We'd be happy, number one, to provide you with with a further document describing the exact methodology by which we received, and of course it varied in particular cases. The other thing that I would say, Your Honor, is the very reason that we are seeking a subpoena is to obtain all of this material in a single form, in a certified copy, not in piecemeal fashion, with a certification that documents how it was obtained, how it was transcribed, and that, in essence, to provide a transparent process that will not only provide us with an accurate record of what transpired during these calls and visits, to the extent the sheriff's office has such documents, but also one that's produced during, again, a regularized, formalized process under the supervision of the court that's transparent and that contains the very kind of chain to the information that you're requesting.
No, but Rule 17 requires the court, in order to allow this, since you didn't get an affidavit from anyone from the sheriff's department, and you're not required, I'm not saying you're required to get an affidavit from the person who listened to the calls, but the affidavit requirement in Rule 17 requires the court make a determination that the hearsay here is reliable, which, if it had said the person monitoring wrote a report which was read, that would, the court might be able to make a determination whether that's sufficiently reliable. Or if it was the person who monitored phone, but without knowing, I don't see how from this, I'm assuming the court can infer that your paragraph 16 is based on 15, even though it doesn't say so, but assuming that's a reasonable inference. There's nothing in here, or what is there in here, that would allow the court to determine that hearsay is relevant?
Well, I can represent to you today, Your Honor, that...
Based on the affidavit, that's
okay.
what Lamprey replies. So.
In the affidavit, I agree with you, the inference is that the information was provided in exactly the fashion that you described. In fact, recordings, raw audio files have been provided. Those have been listened to by members of the prosecution team, and that the averments contained in the affidavit were premised on that information that was obtained firsthand by the members of the prosecution team, having listened to the raw audio files.
Thank you.
Your Honor, I think this is an extraordinary motion. As I understand the requirements of Rule 17 as explicated in Lampron, there are basically, to paraphrase, there are three. We really need this stuff to try the case, number one. Number two, we can't get it in any other way unless the court enters an order. And number three, it's not a fishing expedition, but rather the specific material we're asking for is going to be material to proving or disproving an issue in the case. And I don't think they come close to meeting any of those requirements. The whole predicate for this motion appears to be some, in my experience, rather bizarre partnership between the jail, which is housing Mr. Hernandez, and the district attorney's office, in which the jail apparently is operating as an agent and an arm of the prosecution and handing over materials that they think are interesting to the district attorney's office as they see fit. So, number one, they don't need an order from this court to get this stuff. They're already getting the stuff.
But don't they? Because they say in this filing that copies of, as opposed to being advised of what may be in the contents, won't be provided without a court order. And is there anything inappropriate about an institution to the under penological standards if they become aware of should they become aware of or believe that someone may be using coded messages or other things to be using their telephone system, not to let a prosecutor know?
Well, number one, Your Honor, it's not clear to me from this filing, such as it is, and I would take issue with that this is even an affidavit, that they don't have copies of this stuff. They say they don't. It's true they don't have a certified copy of it that has a ribbon around it, but I don't know that they have made a representation to the court that they don't have copies of the recordings that they're talking about. They just told the court that they've actually listened to the recordings themselves. So they're not apparently relying on the jail for the contents. Apparently they have firsthand information about the contents, although they have not seen fit to provide that to the court in their filing. So I take issue with the fact that they need an order of the court for this stuff because the jail is apparently already feeding it to them. Secondly, Your Honor, I mean, this is a grossly overbroad motion. This motion, and I think Mr. Michael just reiterated, they want every recording of every phone call Mr. Hernandez has made from the day he entered the jail in June of 2013, not only through the present date, but into the future until the conclusion of the trial. I mean, if that is not a classic fishing expedition, I don't know what is. I mean, where is the relevance of, they claim that a few of these calls they say are relevant, although as the court points out, they do not show this hearsay as reliable, which is a requirement under Lampron. They do not say the source of this hearsay information, which is a requirement under Lampron. But somehow to try to parlay what they say are some calls that they claim have something to do with this case into we want every call the defendant has made, is making, and will make into the future, it simply goes way beyond the bounds of certainly of the SJC's decision in Lampron and its progeny. So this is nothing but a fishing expedition, and I mean, frankly, if this is what they say they need to try the case, one wonders about all the representations they're making in court about, you know, what a strong case they have against Mr. Hernandez. So that's the phone calls. They've also, Your Honor, asked for the visitors' logs and records regarding visits to Mr. Hernandez. And the only justification they set forth for that is, well, Cheyenne Jenkins, Mr. Hernandez's longtime girlfriend and the mother of his daughter, and Tanya Singleton, his family member, have visited him in the jail. Ipso facto, they argue, we need all of his visitors' logs. The fact that these two people who are close to Mr. Hernandez have visited him in jail, how does that demonstrate that visitors' logs in general will lead to contain specific information which will prove or disprove an issue in the case? It doesn't come close to meeting that requirement. They're simply, again, interested in who's visiting Mr. Hernandez, and frankly, I would be shocked if they're not being told that every day by their compatriots at the jail anyway. So they don't need these records because the jail is telling them all this stuff anyway, and they have not come close to meeting the standard in Lampron to show that this is anything but a fishing expedition, and I ask the court to deny the motion.
Thank you. Could you just indicate, does the Commonwealth actually have physical possession of any of the recordings?
Yes, we do. Some of them, Your Honor. I mean,
and have those been turned over? And if not, why not?
they will be in due course, Your Honor.
What do you mean in due course? Why haven't they already been turned over? What does the due course mean?
These are things we've acquired relatively recently, Your Honor.
Like when?
Your Honor, I can provide you with the list of the dates that are provided on different dates, Your Honor.
When was the first such recording physically provided?
I personally don't have that information, Your Honor.
Do you believe it's more than a week ago or more than 2 weeks ago? Ms. McCauley, do you have that information?
I can say more than 2 weeks ago, Your Honor. We brought the motion to give the attorneys for Mr. Hernandez requested this information.
Well, you haven't brought it on their behalf. What they requested was what you had in your possession, custody, and control. And you're now telling me that you actually have things in your possession, custody, and control that they've asked for that you didn't turn over. I
Your Honor, if I can be heard first, before. There is a protocol that, with the jail, that in terms of investigation, they will provide us calls. If we want to use them in court or provide them in a court proceeding, they want them to be certified. We bring the motion to get the complete copies, so no one's going to suggest that somehow these are bootlegged or they're taken out of context, that we get a complete set of all the calls. That's why we bring this. We need the subpoena to do so. Okay, or to provide them would be against what the protocol that they've told us how they would, and will gladly do that should the court order it. But we're trying to comply with what they have indicated to us, the use of the calls. Investigation, they share those with us. In terms of producing them in the course of discovery or in the course of a trial or getting ready for trial, that they want to have a subpoena. So that's why we filed the Rule 17.
I mean, I have to say, Your Honor, I am somewhat astonished to hear Mr. Sultan take the view that he's taken. These are materials they've requested.
They requested what was in your possession, custody,
We're trying to
control.
provide them in the most complete form, through a transparent process, one that gives them the opportunity to assert any question of privilege that might exist. I mean, this seems to me to be, and from every perspective, advantageous to the defendant as much as it's advantageous to us.
Are you saying that, I mean, I don't see a congruence of positions. I hear Mr. McCauley saying in order to have a complete, thorough copy, usable at trial, admissible at trial, the Commonwealth has filed this Rule 17 motion. You seem to be saying that you're filing it because the defendant has requested. So if the defendant withdraws his request for recordings other than those actually in your possession, which you're saying you would withdraw the Rule 17 motion?
Your Honor, you're misstating what I just had indicated to the court. I thought I made it perfectly clear. There is a protocol. We're trying to comply with our duties to provide information that we have or that's been furnished to us or that we have knowledge of. The jail has a protocol as to how they will give us this information, and we have agreed to that. If Your Honor orders us now to produce that, we'll gladly do that, because later then we're not subject to, oh, they violated the protocol. We're trying to honor the protocol that was agreed to with the sheriff, and as well doing it in a fashion, so I don't think there's any inconsistency about the respective positions here. We're bringing it to the court's attention. They raise it in a motion, or in their letter to me. I indicate we'll do it by Rule 17. They object to that. So we're caught in between. So either the court can order us to do it as we're required under discovery, and again, that'll be a violation of their protocol, or we sought the Rule 17 procedure, but there is nothing underhanded about what we're trying to do and their knowledge about these calls and them being known to us. So we bring the motion, we outline the whole basis as to why they're relevant, and we do it in a form to make sure they're certified. They can then be brought into the court. They're now in a position to be used later on. The sheriff is happy because he knows we're complying with the protocol that's been established. So to suggest there's anything else going on is just inaccurate.
Thank you.
Your Honor, if I may. What I understand Mr. McCauley to be saying now is that the Commonwealth has obtained bootleg copies of Mr. Hernandez's phone calls from the jail.
Adjectives.
Okay, well, that was his word, not mine, Your Honor. And I would like, and what we've asked for, are, as the court correctly said, we want copies of whatever they have. So whatever they have, we want copies of. If they claim that they're doing this because some kind of protocol of the jail requires it, frankly, I don't care about making the sheriff happy, and I would like a copy of whatever protocol they claim exists, which, number one,
Defendant's opposition pointed out that the affidavit was not signed under pains and penalties of perjury. The Commonwealth did not file a revised affidavit either before this hearing, nor did it submit one at this hearing. Therefore, under Lamprin, the court is entitled to go no further. The denial is without prejudice to refile with an affidavit, and with an affidavit that contains enough detail to enable the court to determine the reliability of the hearsay. The Commonwealth's filing is silent as to whether the person providing the information to the Commonwealth was the person who actually heard the calls, or whether that person put what he heard in a report that was read, or whether that person told someone what he had heard, who told someone else, who ultimately informed the district attorney. Without knowing how many layers of hearsay there are, there's no way for the court to determine whether the hearsay is reliable. If indeed the prosecutor has listened to the calls, there may be direct knowledge by the affiant, but there's simply insufficient given to this court in the purported affidavit for the court to make a determination as to reliability, and for that reason the motion is denied. Further to the, and as I say, it's not without prejudice. I'm certainly not precluding the Commonwealth from refiling its motion with a proper affidavit that meets the Lamprin standards. To the extent it seeks recordings of calls which have not yet occurred, the court finds no basis to allow that kind of order. It would require the filing with this court every time there is a phone call. The purpose of Lamprin, as the courts have said, is not a discovery tool with respect to recordings in the past. Recordings in the past stand on a very different level than recordings in the future. Certainly a Lamprin motion, if allowed, with respect to recordings that have already taken place, would not preclude the Commonwealth from filing further Lamprin motions in the future if the Commonwealth could support its request for such calls with reliable hearsay. with respect to the documents that are in the actual physical possession of the Commonwealth, the defendant requested all recordings and transcripts of telephone calls from jail made by the defendant or any co-defendants which are in the custody or control of the Commonwealth, along with documentation memorializing how the Commonwealth obtained such recordings. It did not ask or request that the Commonwealth file a motion or seek to obtain any recordings it does not already have. And indeed, the defendant is opposing the Commonwealth obtaining recordings it does not already have. The Commonwealth, in response to that request for discovery of all recordings and transcripts of telephone calls from jail made by the defendant or any co-defendant which are in the custody or control of the Commonwealth, along with documentation memorializing how the Commonwealth obtained such recordings, stated, agreed. The Commonwealth is ordered to produce them by Monday.
Just as to that last part that you wrote, what I agreed to, we had a conference, and I had already told them I was going to be filing a Rule 17 motion. So I think to read that in that...
I'm reading the letter of January 23rd, 2014, which states agreed. If it's something other than what's in your letter, if there was a conversation other than what's in your letter, that you only agreed to produce them if they were obtained by a Rule 17 document, I don't have any reason to doubt if that's what you say you said.
That's exactly what I did say. And again,
the letter that you sent, the letter that you signed simply says agreed.
I understand that, Your Honor. That letter I didn't file with the court. I sent to them. I told them before I sent the letter, I'm going to be seeking this with a Rule 17 motion. So they clearly understood. There was no misunderstanding there. So for the court's understanding, I'm pointing out that fact, not that you're suggesting, oh, you said right here in writing that you've agreed, because that's not accurate.
Thank you.
Your Honor, just to correct the record, Mr. McCauley did tell us during his meeting with us that he intended to file a Rule 17 motion. However, he did not tell us he had any such recordings in his possession at that time.
Thank you. The court does not deem this letter, given what you've said, Mr. McCauley, you said, and I'm not going to try to parse or what actually was said or wasn't said. I don't deem you to have waived any position by the Commonwealth by writing agreed without indicating further in writing that what you had intended was only to produce if the Commonwealth obtained it by discovery. But I find that these are all documents that are currently in the possession of the Commonwealth, and that the Commonwealth is obligated to produce them under the automatic discovery rules, and I will order the Commonwealth to produce them by Monday at close of discovery. The next is a motion for bill of particulars.
Yes, Your Honor.
It appears that what you're seeking is, the bill of particular is to seek the Commonwealth to indicate whether Mr. Hernandez is going to be tried as the actual shooter or as a joint venture. Is that?
With respect to count one, yes, Your Honor, that's exactly what we're seeking. Based on the discovery we've received, their position is that they have evidence that there were 3 people at the scene where Mr. Lloyd was killed, and only one person in this case has been charged with murder. We don't know whether their theory, under Zanetti and its progeny, including most recently Horn, 466 Mass, 440 at 446, joint venture requires evidence that more than one person participated in a crime. So we don't know, as we sit here today trying to prepare for trial, whether they're alleging that Mr. Hernandez fired the shots which killed Mr. Lloyd, or whether they're alleging that he assisted somebody else in that endeavor. And I think...
have to pick. I mean, why can't the Commonwealth at trial ask for a Zanetti instruction that Commonwealth can prove the defendant guilty of murder if it proves beyond a reasonable doubt he participated in the commission of the crime alone or with others? What requires them to choose now,
well, they don't have,
or to limit themselves now to that?
Well, Your Honor, as a generic matter, I agree with you. There are many cases where the Commonwealth can proceed on both theories, particularly cases that I've been involved in where a number of individuals are charged with murder. They can keep all those theories going. But bill particulars is obviously a discretionary call by the court. The question is whether or not the defendant is on fair notice as to what he's accused of doing so that he can defend himself. And under the circumstances of this case, where for whatever reason the Commonwealth has chosen to charge the other two individuals at that scene with offenses that are essentially post-offense conduct, I think we do have a right to ask the Commonwealth through the court to tell us what you claim Mr. Hernandez's role was in this crime. And that's...
It may be, as happens often, that the precise identity of the shooter is not known, and the Commonwealth is not required to prove the precise identity of the shooter.
That's true, Your Honor, but they only get a Zanetti instruction if they're claiming that more than one person was involved in the crime. And based on the way they've charged the case, I don't know that they're alleging that. So we don't know really what it is that we're trying to defend against here. If other people had been charged with murder, I would agree with Your Honor. They could pick and choose, and we're basically forced to proceed on both theories. But here there is no other people who are charged with participating in the murder of Odin Lloyd. So we don't know whether we are facing whether there's some unnamed joint venturer that they claim is out there, or whether they claim that Mr. Hernandez was the shooter. And it's difficult to...
But the Commonwealth says, we're reserving all of our options. That gives you the notice you're seeking?
They have every right to reserve their options, and they can obviously amend a bill of particulars. They can say, well, right now, we say that Hernandez is the shooter, and we reserve our right before trial to say, well, maybe somebody else is the shooter. But given the way they've charged the case, it leaves us in the dark as to what Mr. Hernandez is actually accused of doing, and it would enable us to prepare for trial to have that information, and that's why we're seeking it.
Okay.
As to the other indictments, Your Honor, they're boilerplate firearms indictments, and frankly, there's a bunch of firearms and ammunition which has been seized by the Commonwealth, and we need to know as to these remaining 5 counts, specifically what are the firearms and what particular ammunition are they alleging Mr. Hernandez was responsible for possessing, because it's not at all clear from the discovery, and it's certainly not set forth in what are boilerplate and in some cases identical indictments.
Thank you.
Your Honor, as you pointed out, the law is quite clear in this area. Williams states, I think without any ambiguity at all, the Commonwealth is not required to specify in answer to a request for a bill of particulars the type of murder it intends to prove, nor the theory under which it intends to proceed. As you point out, the Zanetti decision, post-Zanetti, it's even more clear what our burden is at trial. We need to merely prove that the defendant knowingly participated in the commission of a crime, either alone or with others, with the intent required for the offense. That is our approach. At this point, we are not willing to say anything more than that, and our bill of particulars will make it clear that the defendant was present at the scene with others and acted in concert with others, and either himself or in concert with others, as the Zanetti case requires us. He either acted in concert with them or alone with the intent required for the particular offense, and that is the alpha and omega of our obligations under the law. I could provide you with 4 or 5 other cases besides Williams which come out exactly the same way in terms of the Commonwealth not having any obligation whatsoever to provide any information relevant to the theory under which it intends to proceed where the offense of murder is charged in a bill of particulars. And so our position is exactly coincident with the settled law, and I can't say that I understand completely the basis for Mr. Sultan's request.
And with respect to the firearm and ammunition charges, does the Commonwealth have any objection to specifying the specific firearm, rifle, large capacity feeding device, weapon, or ammunition the defendant is alleged to possess?
Absolutely none, Your Honor. We fully intend to do so. Absolutely.
Thank you. The defendant's motion for bill of particulars on count 1 is denied. A judge should not order particulars that in their requirement for detail or otherwise amount to the imposition of a straitjacket on the prosecution. That's exactly what the defendant's motion would accomplish. If allowed with respect to the murder charge, the defendant has been given discovery in this case, which shows to the extent there were other persons present. The facts of the case have been provided to the, that are in the Commonwealth's possession, have been provided to the defendant. Where there is evidence that more than one person may have participated in the commission of a crime, the jury is to be instructed that a defendant is guilty. If the Commonwealth proves beyond a reasonable doubt that the defendant knowingly participated in the commission of the offense, either alone or with others, with the intent required for that defense, the jury is not even required to determine whether the defendant is liable as a principal or as a joint venturer. Proof of the identity of the shooter is also not essential to proof that the defendant committed a murder. The fact that the co-defendants have not been charged with murder doesn't preclude the Commonwealth from presenting a case to the effect that one of 3 persons shot the victim and that the defendant knowingly participated in that crime. The Commonwealth is not required to specify in a bill of particulars the type of murder it intends to prove or the theory under which it intends to proceed. As for counts 2 through 6, the motion for bill of particulars is allowed without objection. We would ask that the council file a pretrial conference report in the next couple of days, meet and have a pretrial conference report filed by sometime next week. Can we today schedule filing dates for any non-evidentiary motions to dismiss or suppress? Or
I'll address that if I may, Your Honor. What we would propose is that we have a date of April 30th to file motion to suppress and motion to dismiss, with the understanding that we would be allowed at a later date to file other motions to suppress and other motions to dismiss.
on different grounds?
On grounds other than the ones we file as of April 30th. For instance, we've had the grand jury minutes for some time now. We're working on a motion to dismiss on various grounds, Odell and McCarthy. We're working on a motion to suppress some of the evidence, but we haven't gone through all the discovery. We just
these non-evidentiary motions,
yes.
Obviously the motion to dismiss.
Yes, they would be 4 corners, either
right.
4 corners.
Non-evidentiary motions to dismiss, and
Yes.
Obviously, and the non-evidentiary motion to suppress, and then at a future time, any evidentiary motions.
With the caveat that as we go through the material that we're still just receiving, I mean, this last week we got about 50 more DVDs, including from a search in January. So I don't know if there are going to be other 4 corners motions to dismiss or suppress to be filed at a later date. So to get the ball rolling, what we propose is to file some motions to dismiss and suppress by April 30th with an understanding that we are allowed to file others at a later date. And probably by that time we'll be in a position to tell the court how far along we are.
Is there... if I schedule those for hearing late in May, is that give the Commonwealth sufficient time to file its response, or would you rather meet?
As long as we have at least 30 days for our response, Your Honor.
So the answer is no, you'd rather me do it in June.
If it's filed on the 30th, Your Honor, again, either late May or early June, I guess would...
Give you 30 days, you have till May 30th, and how about June 16 for a hearing? Afternoon, we should be able to, since it's non-evidentiary, do it in the afternoon. Right. I mean, I'll assume we can do it in the afternoon. If you think for some reason it's going to take more than 2.5 hours, we'll have to reschedule it, but I assume I'll be on trial in the morning. And so the June 16 will be the pretrial hearing in this case as well. So it would be the pretrial hearing and a hearing on non-evidentiary motions to dismiss, non-evidentiary motions to dismiss. If there are any outstanding discovery motions, they can be heard on that date, or if there's some reason to hear them earlier, we'll do that. And the filing of all non-automatic discovery motions under Rule 14A2, if there are any, should be done by that same April 30th date. And to the extent the bulk of the discovery has been provided, the Commonwealth may want to file next week along with the pretrial conference its certificate of compliance, recognizing what is still in the pipeline to be provided. And anything else to be taken up today?
Your Honor, just there's the pending motion regarding extrajudicial statements.
Right. I received your post, each of you a post, and I've received each of you, from each of you, a post-filing memorandum of law. The court has the matter under advisement. You've both filed very helpful legal memorandum, and I don't see any reason at all to have any further argument. My recollection was we had a very lengthy argument last time, unless there's something that one of you believes you did not state sufficiently articulately in your filings, in which case I'll give you a moment or two, but otherwise the court has received all the filings, as well as obviously the memorandum that were filed prior to the hearing, and has considered the arguments at the hearing.
No, I would just add, Your Honor, that our understanding was that the court wanted information from the parties on suggestions for reasonable steps only, and what we ended up with was a relitigation of the entire issue.
I've looked at your post
Thank you.
submission. Again, if there's anything that you don't think you stated or that Commonwealth